Yeah, thanks, John. And thank all of you for joining us. We always look forward to doing this. I wish we were all in the same room, but that can't be helped this time. Uh, my topic today is the CFPB. And as some of you might remember, in previous presentations on this topic, I've not been very kind to the CFPB. Um, and I wanted to kind of take a few minutes to kind of introduce what uh, some conversations I had before we start through the presentation, some conversations I had with some former colleagues when I worked at the Federal Reserve, um, and how they're feeling with respect to what happened to them during the Trump administration, or how they perceived that, and what they believe is going to happen now. And I started my career as a thrift examiner with the Federal Home Loan Bank of Indianapolis, then the Office of Thrift Supervision. And we were right in the wake of right in the middle, rather, of the thrift crisis. And once the thrift crisis had kind of become under control, the present administration, the Bush administration, started closing offices and started shutting down thrift examiner, or started reducing staff with the OTS and really cut things back. And I remember before moving on to the Federal Reserve Bank of Chicago, just the morale at the office and the morale among examiners who were traveling around, still trying to do the job, but were really moving quickly from bank to bank or thrift to thrift, and having to do the same job, but on a double time basis. So it's very interesting, and I remember that. Um, and when I was talking to the CFPB folks, it seemed like the same thing during the previous administration. I remember going to the Federal Reserve Bank of Chicago for a regulatory conference, and the speaker from the CFPB at that point, right after the election in 2016, had nothing to say, was in shock, and looked like the world had come to an abrupt end. Um, Obviously, the agency continued to function throughout the administration, but as we'll see in a minute, a lot of things happened, and we're going to kind of go back through what happened then and what we perceive, and what these examiners told me off the record they perceive to be happening now. And again, many of you aren't affected by the CFPB directly, but indirectly, we all know that the tone for the regulatory enforcement and a lot of the enforcement actions that come out of the CFPB kind of trickle down through the prudential regulators. And it'll be interesting to see how that continues, or if it doesn't. So to start, we have some constitutional questions that were resolved, or we think they're resolved. And we're going to look at the CFPB under President Trump, as I said, and then in the short time that we've had to evaluate under President Biden, what we think or what has happened, and then try to predict the future to see what is going to, what we have in front of us with respect to this particular agency. All right, next slide, please. So if you remember, the Congress created the CFPB as an independent agency, federal agency, and had a single director that was appointed by the president and confirmed by the Senate, but only could be removed in the event of very narrow basis: inefficiency, neglect of duty, or malfeasance in office. So this was challenged almost from the beginning, and also challenged was the actual existence of the agency itself. So in a case decided in June of 2020, the agency leadership issue was resolved, and the Supreme Court held that Congress had in fact overstepped its constitutional boundaries and when it insulated the CFPB's director's removal by the president. But they stopped short of striking down the CFPB in its entirety, and also some other ancillary questions that we'll also talk about. Go ahead to the next slide, please. So while we have resolution on the status of the director of the CFPB, one of the issues that came about was what happened while the agency was quote unquote unconstitutional. What about all those decisions that took place and the actions of the CFPB? Well, in the issue with SELA law, that was remanded to the Ninth Circuit to determine. However, then Director Kraninger decided to ratify a large majority of the Bureau's previous or existing regulations and actions taken after January 4th, 2012. The CFPB did not, however, ratify all pending or resolved enforcement actions and indicated that those would be made separately. So we may still have a lot of litigation to come on that particular issue. But we do have some sort of resolution as to the authenticity or the agency itself. Next slide, please. So let's start to look back at the CFPB under Trump. It was clearly Acting Director Mulvaney sort of took the teeth out of the enforcement arena with the CFPB. And this was confirmed by a lot of the examiners that I talked to from almost from day one. They were told that there would be significant staff reductions, that certain enforcement actions and investigations that were ongoing would need to be wrapped up in short order. And even those of considerable magnitude were sort of dismissed or resolved quickly. They did not get into any kind of discussion on specific actions, but primarily they said that the issue that had been abandoned the most in their view was the anti-discrimination laws that were being pursued and disparate impact cases that were trying to be brought. In fact, Acting Director Mulvaney eliminated the enforcement authority for the Office of Fair Lending and Equal Opportunity within the agency. Also, in those actions that were actually taken, the CFPB significantly reduced the penalties that it hit actors with when issuing enforcement actions. Next slide, please. So the tone at the top was clearly, let's say, bank friendly. So Kraninger, though, sort of stopped the bleeding, if you will, and stabilized the agency's number of employees, resumed enforcement actions. Those enforcement actions that were resumed, however, were focused on areas that were payday lending, mortgage servicing, and other issues that had traditionally been pursued by the CFPB on a case-by-case basis, and not issuing large orders or any kind of agency guidance that would sort of rein in practices that they did not particularly like. The penalties also continued to be very low in the enforcement actions that the office was issuing. Some were only $1. So they were definitely sending a message about the enforcement under the CFPB under that administration. Now, I'm told that the prudential regulators, lacking much guidance from the CFPB in these areas, kind of pursued their own agendas. Next slide, please. But there was a dramatic drop in enforcement actions. even among the prudential regulators. The FTC, the DOJ, HUD, and CFPB really eased their enforcement activity and targeting sort of the same areas that had been targeted in the past, but were less impactful than in previous, under the previous administration. Next slide, please. As you can see, CFPB enforcement actions by year. This is illustrative of what I was just talking about. 2015 and 16, you had 54 and 42 actions. There was 36 in 2017. 2018 and 19, though, significantly lower. And then the 2020 shows that Craniger started putting out more enforcement actions. But again, it doesn't really tell, these numbers don't really tell the whole story. They kind of illustrate the enforcement activity, but the real story sort of resides in what they said and what they were about. So to date, there have been 7 enforcement actions. I didn't check it today, so I don't know if anything's been issued today, but there were 6 under the Biden administration, 1 under the previous administration. Next slide, please. So to kind of summarize, the CMP's fines as enforcement tools trended down during the Trump administration. And while Director Craniger increased the number of enforcement actions, the penalties were often small. And as you know, sort of the stick that the CFPB had used in previous years was to make examples of, and usually larger banks with significant penalties to show, to sort of set the tone that we're not going to, the agency was not going to tolerate certain behavior, and that it would, in fact, take action against banks that were, in their view, going too far. Next slide, please. So the areas of enforcement tended to be the same things: the credit cards, overdrafts, mortgage servicing, debt collection, auto loans, payday lending, some fair credit, but not as much, and UDAP as well. But again, remember that UDAP's definition was softened under Craniger as well. Can you go to the next slide, please? The Biden administration, of course, promises more aggressive enforcement approach as we move into this, and the leadership changes that have been proposed by the Biden administration sort of reflect this. Rohit Chopra, who was the current commissioner of the FTC, has been nominated to be the director of the CFPB. Next slide, please. He served as the Federal Trade Commissioner since May 2nd, 2018. He helped launch the CFPB in 2010, and he served as the assistant director of the CFPB with a focus really on the student loan topic. Next slide, please. Chopra appears to be reminiscent of Cordray. He worked under him for a significant period of time and sort of developed the agency. And in his testimony before the Senate Banking Committee, it's pretty clear that the history of aggressive enforcement actions he felt was justified, and that the CFPB should continue to hit areas very hard. And he felt that the FTC did not use its enforcement activity effectively because they didn't use all of the tools that they had. Next slide, please. So trying to predict the future, you have to look at what the nominee has said. And in his testimony, his own words, "We should enforce the laws that have been delegated to us. It's particularly important when it comes to anti-discrimination. There are new ways in which financial institutions are using behavioral advertising, new forms of data collection, and we need to make sure that we are offering a robust way to understand how they can comply and hold them accountable when they're not. So in this statement, I think it unpacks the things that we suspected. The return to the anti-discrimination focus, the looking at areas that are on the sort of burgeoning areas that banks are now engaging in, some of the things that John talked about, particularly with the fintechs, the understanding the behavior of their customers, how are they using the data that they collect, and for what purposes. And I think you're going to see a clash between what John was talking about in understanding the behavior of your customers for the good things that you have to do, and then the opposite side of that is, are you abusing the information that you're collecting, and how are you collecting and keeping it in the eyes of the regulatory agencies? Next slide, please. They also restored the Office of Fair Lending and Equal Opportunity. I'm told their enforcement authority has been restored. This was the one time when speaking with the CFPB folks that they were sort of gleeful. And I don't mean that in a way where they were, oh, great, we can go hurt banks. That's not what I mean by that. I think they were understandably heartened by the fact that their work now would mean sort of the things that they had joined the agency for. And these folks they deeply care, I believe, about what they're doing and they're looking at, and believe that it's a societal harm that comes to many consumers that they need to try to correct. And so I think they felt that their mission was back a little bit under this new administration. And so one of the other issues was the reversal of creditor's abuse standard. And the one thing that I dislike, and I think I've said this on many occasions, is rulemaking by enforcement. That's one thing that Mr. Chopra has been very vocal about with the FTC, and he felt that the FTC did not look at areas that maybe had no rule violations technically, but if that they didn't like those areas, that they were or they didn't like the activity that was being perpetrated by organizations, and that they should have gone out and eradicated that through enforcement actions. Next slide, please. John talked about agency rulemaking, and you understand the notice and comment procedure, and it's very impactful. Agencies learn a lot by taking note of the comments of the industry and in the opposing side. Maybe it's consumer advocates when they're putting out consumer laws. I served on a couple of committees at the Federal Reserve where we evaluated proposed rules, and we also looked at comments from both sides. And some are crazy, some are, as you could expect, but many, and I think the vast majority, are very thoughtful and are very, need to be dealt with in a manner that really decides the issue of whether the regulation is really going to result in its intended action. And what I mean by that is, when the reserve banks, for example, the way we used to do it, we would go to the board of governors and tell them our thoughts based on what we were seeing in the field and what we thought the rules would do to our banks, and what we thought about the consumer side of it as well. And we'd have a discussion, and the board would go talk to the other agencies to see whether or not our changes would merit any kind of reflection in the final rule. Sometimes it did, most of the time it didn't, but it's a thoughtful process. What I dislike greatly is when agencies engage in rulemaking by enforcement. And I understand there are times when there's a practice that's just so egregious that it may not violate anything, but it's tantamount to fraud or whatever else. Then the agencies need to do what they can. But extending existing regulations or making interpretations of catch-all rules like UDAP are very dangerous for the industry. So imposing new or expanded regulatory expectations or standards through enforcement actions is what I'm talking about. Usually, like I said, the agencies deny they're using this approach. NASD was very, very strong at that because unlike banking, most banking rules, the SEC and the NASD then had a catch-all provision that permitted them to go after anything they didn't like. And they used that aggressively. And then that's trended back through Director Cordray, who explicitly defended that approach during his tenure at the CFPB. He indicated that although not substitutes for regulation, they need to be deployed as a deterrent to practices that can harm consumers. But the problem with that is, who is the arbiter of that? And that's solely within the CFPB's guidance. Next slide, please. And like I said earlier, and what John had said, that the explicit and specific rules implementing concepts that have been known to the industry for a long time through the notice and comment process is what we've come to expect. And I think that's the accepted process throughout administrative law. I mean, that's what it's founded on. But when you try to develop expectations in the absence of rules, that's fine as well. And I know the FDIC and the OCC particularly are good at providing guidance on areas where banks are conducting certain practices and they may cross the line, and you'll see an announcement by the FDIC or some other, or the OCC, where they're talking about these practices and that banks should be aware that this could be considered to be a violation. That's a great approach to aim at practices that are unfavored, while at the same time working at modifying existing rules to show the real teeth and the real actual law or rule that's being violated. Next slide, please. I guess one of the things that I'll go back to is the UDAP, because that's the catch-all provision that has had the attention of the whole banking world when it came out that abusive was being added to the UDAP provision. And Kraninger kind of cut that back to focus only on abusive cases when the harm to the consumer outweighed the benefits. The CFPB was quick to rescind this in March 2021, stating the Bureau has determined that it should exercise the full scope of its supervisory and enforcement authority to identify and remediate abusive acts or practices. Even though not confirmed, that looks very familiar to the comments that Rohit Chopra has already talked about in his Senate testimony, particularly the dialogue between him and Elizabeth Warren. Next slide, please. So the focuses and trends that we have seen and that we continue to see from the CFPB are kind of the same old things. The payday lending, where they're going through the various truth in lending type disclosures and violations, failure to disclose automatic renewal features and so on, and getting at those areas that they've traditionally attacked. And I think I was told by the CFPB's folks that they are pretty intent on delivering some blows to these particular areas through restitution and CMPs. Next slide, please. Another area that kind of coalesces with what John had said, but not necessarily with the CFPB, is the BSA AML. John had covered that pretty clearly, so I'm not going to go back to that. Next slide. So to kind of wrap up where we are, and I think this also is something that we're seeing with our fintech relationships. Be aware of the indirect risks. And the CFPB for the larger banks will focus on this. But the prudential regulators will also have also said that they're going to focus on relationships where your customer is dealing with a third party that you are deemed to be dealing with as well. And so you're going to be exposed to liability for conduct taken by your affiliates and vendors. So your vendor management and those kind of processes are going to need to be very strong as we kind of move into these areas that, my discussions with the CFPB were very clear that they're very focused on how virtual currency, digital assets, and so on are going to become consumer, quote unquote, consumer issues. And they've hired quite a few people to kind of look into these areas. And I think we're going to see some regulation flow downward based on that. You should go to the CFPB's website. And for all the trouble I've made for them over the years, they have a great website. And I think it provides a lot of really good material to keep yourself out of what others have experienced in terms of enforcement actions. Maybe that's lagged a bit in the last few years, but I think that's going to be ramped up now. You may not like what you read, but at least it's helpful guidance. And you should adapt your practices to these expectations, particularly in the early years of the fintech relationships that you'll enter into. Many banks have not leapt into this area. Many banks are, looking at new ideas, any kind of activity that'll bring in more fees. And so what we've always said is go to your board, make sure your board understands what you're getting into, have your consumer compliance people talk to the board and really make them aware of the areas of risk as you see it. And then integrate that into your risk management strategy and do this proactively. Don't make the regulators have to tell you, because you're kind of behind the game at that point. All right, so at this point, that concludes my slides.